Here we are again, Dan and Brendan. We always know, Dan, that we're not going to have to wait too long before something else, you know.
Nope, it's somewhere between 12 and 24 hours is all we ever have to wait.
That's right.
More Trump news, so here we are.
Here we are. And we try to cover legal issues as much as possible on our, you know, these videos that we do. You know, lately in the news has been something that people might want to understand better. That's a First Amendment issue because Donald Trump and his people have been trying mightily to stop two books from being published, one by John Bolton and one, I don't know about you, but if I had a choice between John Bolton's book and Mary Trump's book, because Mary Trump's she's his niece, and she's going to go into all kinds of detail about how screwed up their family is.
And she's also a psychologist too, so she knows what she's talking about.
That's right. That's right.
So you know, I think she's a psychologist, isn't she? Psychologist or yeah. So she's got the cred to you know put some stuff on the record, and yeah, that would be the interesting one to see. Absolutely.
Yeah, that would be first on my reading list if I had a choice between the two. But
right. Between Trump and Bolton, I'm happy to see both of them lose. But
yeah,
the niece, yeah, okay, let's go. Here we go.
Right. So we'll talk a little about both. But what's in the news now is Mary Trump, because she had New York, by the way, has the most screwed up. All lawyers talk about this, right? The most screwed up court system you'll ever see. They call the trial court the Supreme Court, and then the court above that is called the Supreme Court Appellate Division. And the top court in New York is called the Court of Appeals. So they've it's very confusing.
It gives lawyers a headache. If you don't practice in New York, it gives me a headache trying to figure out what court we're talking about.
Exactly. So yeah, but that's important to know because the New York Supreme Court is the trial court, and most people would not assume that, obviously.
Right.
But the New York Supreme Court, i.e. the trial court, a couple days ago issued an injunction ordering Mary Trump not to publish. Simon & Schuster, which is the publisher, and Mary Trump saying they can't publish until they have a hearing, which will be on July 10th. Then the judge from the appellate division, right, the higher appellate court, reversed that, at least as the Simon & Schuster, and said there's no injunction against Simon & Schuster continuing to prepare to release their book. Now, so why are we talking about this? We've got three big points we want to make, as with most of our videos. And the first is that there certainly is a First Amendment issue in play here called prior restraint. And so we're going to talk about that. The second is what kind of remedy a court is likely to provide. In other words, are they likely to actually prevent this book from ever being published, or are they going to give, assuming that the plaintiffs who are challenging Mary Trump win, are they going to give them some other remedy? And so we'll talk about that. And then the third point that we're going to make is that Simon & Schuster, the appellate court, distinguished between Mary Trump and Simon & Schuster and said even if Mary Trump can be enjoined from being the author of a book like this, Simon & Schuster is the publisher, and they can't be enjoined from publishing it. That's at least this judge's opinion, or appears to be. So let's start at the beginning. What's a prior restraint? Dan, and if you could explain briefly the Pentagon Papers case and how this case fits into that paradigm.
Sure. The idea behind prior restraint is pretty simple. It goes way, way, way back to the origins of the common law system, and I teach it like this when I talk to students about it. The rule of prior restraints is. A prior restraint exists if you're not allowed to speak without getting permission from the king first. The idea being that the king only wants people to speak if those people have nice things to say about the king. And the way that we make sure that they have nice things to say about the king is by making them come to the king and get a license, permission to speak first. Well, that whole idea, it doesn't require a whole lot of creativity to see that entire idea is antithetical to our notions of First Amendment free speech. And so as a result, under our American constitutional system, we have a strong, very, very strong presumption against the validity of prior restraints. How strong is that presumption? Well, one of the most famous cases is a Supreme Court decision from the Vietnam War era called the Pentagon Papers case. The New York Times and the Washington Post got a hold of excerpts of a top secret report on American activity and American policy in Southeastern Asia, and decided that they were going to publish excerpts from the report, which they began to do. The Nixon administration reacted swiftly and immediately went to court to seek an injunction prohibiting the Times and the Post from publishing any other excerpts from the Pentagon Papers. The case made its way up to the United States Supreme Court in record time, and the Supreme Court opinion is interesting because the actual opinion of the court is something called a per curiam opinion, not signed by any justices, just an opinion for the court. And basically what that per curiam opinion says is this is a prior restraint. Prior restraints are strongly disfavored under our constitutional principles, and thus no injunctive relief for the president. There were a number of concurring and dissenting opinions, and some of those are interesting, including the concurring opinions are interesting because some of the concurring opinions basically say this: we are willing to assume, for the sake of argument, that publishing these excerpts from the Pentagon Papers will harm national security. But guess what? The president still has no authority under these circumstances to seek injunctive relief prohibiting the publication of this information. So the moral of the story is that when it comes to a prior restraint, courts are loath to do anything that looks like it might be a prior restraint.
Right. And in fact, you know, it's interesting most of the time, and we've talked about this in prior videos, most of the time when the government targets a constitutional right, courts would apply something called strict scrutiny, right? And say, oh, it's okay if the measure, whatever the government's doing, is narrowly tailored to achieving a compelling interest. But this is actually beyond strict scrutiny. It's a presumption, and the court characterized it as a heavy presumption against constitutional validity. So it's simply presumed to be unconstitutional. And yes, asking a court to enjoin publication of something, as you said, is a form of prior restraint. So it's there in this case, right? This case fits. But I think one of the questions people are going to have is, and obviously this is the question that one of the questions the court is grappling with. Mary Trump signed an NDA, a non-disclosure agreement, that was a part of Fred Trump, Donald Trump's father, his estate. When it was administered, there was a dispute, and a bunch of them signed, including the judge. I want to ask you her name, put you on the spot, but Trump's sister signed it. She was the federal judge.
Yes, that's right.
And some other members of the family. Trump's brother signed it, and Trump's niece also signed it. Donald Trump himself signed it as well. So there's this, and Donald Trump is very fond of those. I have never heard of a public figure surrounded by more non-disclosure agreements than Donald Trump has. I mean, if he's the skeleton,
kind of makes you wonder if he's got something to hide, doesn't it?
Yeah. You know,
everybody that comes into contact with Donald Trump of any kind, business, personal, family matters, whatever, seems like everybody's required to sign an NDA. And right. He's the first one to rush to court and say, wait a minute, you can't say that. NDA.
Right.
Kind of makes you scratch your head and go,
Yeah, it does. Because, you know, if I had somebody to writing a book about my life, my question would be, I mean, who the hell would, I'm so boring. I mean, I don't need
who cares?
You need non-disclosure agreements? I don't need non-disclosure agreements.
Right.
What?
Right. I need an agreement to compel disclosure. My life's so boring.
Yeah, right. That's right. Right. So anyway, there it is. He's got his typical NDA, even with, as you say, even with family. And so then the question becomes, this is related to the first point, there is a constitutional right involved in play here. That's the First Amendment, and a serious First Amendment issue, prior restraint. But then the question is, can you contract away your constitutional rights? So that's the next question. What about that one?
And the answer, the short answer is yes, you certainly can. You are free to waive, and that's all a contractual agreement is. It's a form of waiver. You are free to waive your constitutional rights. Courts will look for some indication that you knew what you were doing, that the waiver has to be knowing and voluntary. But that's not going to be an issue in this case because she was represented by legal counsel during the course of these negotiations. So there really is no question but that her waiver of her right to tell all about Donald Trump and the Trump family was both knowing and voluntary.
So what we've got here is, yeah, I mean, if she wanted to publish a book about Donald Trump, it was a mistake documents, which she did knowingly, as you say. So you can contract away your constitutional rights, but there's a but. Okay, so we've got our big first point down. There is a First Amendment issue here, but you can contract away your First Amendment rights. Point number two is, what is a court going to do about it? And that's where things started to really get interesting in this appellate court decision. And I'm going to throw this to you because you know more about equity and remedies and injunctive relief than I do from your litigation experience. So what caught your eye about the appellate court judge and his opinion about, let's say that she did breach her contract, what a court ought to do about it?
Yeah. The thing about equitable relief, and an injunction is simply a form of equitable relief. And by the way, since we're on the subject, let's distinguish the different kinds of equitable relief that are available. They come in, injunctive relief comes in basically three flavors. The first is something called a temporary restraining order, a TRO, and that's what the trial court issued in this case, a temporary restraining order. The idea behind a temporary restraining order, as the name suggests, is it's intended to be a short-term measure that's designed primarily to protect or preserve what's called the status quo, the way things are right now. We don't want one party to go and do something imminently that might change the relative positions of the party, pending the opportunity of a court to have a look at this dispute. So the court will, as it did here sometimes, issue a temporary restraining order just to keep the parties on an even keel, pending the issuance or review of type 2 injunctive relief, which is something called a preliminary injunction. The preliminary injunction in this case is scheduled for a hearing on July 10th. So you can see, trial court issues a TRO, but that's only going to be effective up until July the 10th when the court has a preliminary injunction hearing. Both sides get to show up and put on their evidence, and the court will decide whether an injunction should be put into place pending the remainder of the litigation. Once the litigation is complete, that may lead to the third kind of injunctive relief, which is something called permanent injunctive relief. And here, as the name suggests, the injunction outlives the lawsuit itself. It goes beyond the termination of the lawsuit, and it binds the enjoined parties past that date. So where we are at this point is trial court issued a TRO restraining Mary Trump and Simon & Schuster from publishing pending the court's opportunity to hear the application for a preliminary injunction. But if you are, in this case, the plaintiff and you want injunctive relief, you can't just show up in court and say, Judge, we think we should have an injunction here. The law requires that the party seeking injunctive relief has to make certain threshold showings. For example, that party has to show that there is an imminent risk of harm. Not harm down the road at some indefinite future point, but that harm is imminent. The party also has to show, and this one is key, the party requesting the injunction has to show that that party has no adequate remedy at law. And that's a big one in this case. Because when we speak of an adequate remedy at law, what we're really saying is damages. If damages will adequately compensate the injured party, that is to say, put the injured party in basically as near to being whole as possible, then the general rule is an injunction will not issue. So one of the things that the courts look at in cases like this is, will damages adequately compensate the party that's seeking relief? The third thing that a court does when it's asked to issue an injunction of some sort is it balances what are called the equities, the interests of both plaintiff and defendant, and as well the interests of the public. A court is supposed to take into consideration the public's interest. How will that interest be benefited or burdened if an injunction does or does not issue? So, as we said, trial court issued a TRO. It has gone up to the Court of Appeals. The Court of Appeals has said, Mary Trump, you remain bound by the TRO because you signed a contract, an NDA, and for the time being, we're willing to hold you to it. But the same is not true for Simon & Schuster. Simon & Schuster didn't sign any kind of a contract, and the appeals court said, at this point, we simply don't have enough evidence to allow us to say that Simon & Schuster, the publisher, should be bound by this temporary restraining.
Right, and that's the third major point. As to the second one, your point about Simon and Schuster being a separate party. As to the remedy here, I thought it was interesting in this case that the appellate court judge said he clearly fired a shot across the bow of the lower court, the trial court, which issued the TRO as to both Simon and Schuster and Mary Trump. The appellate court judge said, it's when you're balancing these interests, balancing these equities as you talk about, and especially looking at the public interest. It's one thing when you know something or you've written a book about some New York real estate developer or I don't know, D-list reality TV ringmaster. It's another thing when you've written a book about the President of the United States. I always tell students, I don't know if you do the same thing, but when you look, the First Amendment, if we're going to be real about it, is a little bit of a sliding scale in terms of what kind of speech is more protected than other kind of speech. And the most protected kind of speech is political speech. And the more controversial it is, the more protected it tends to be. I don't need the First Amendment to protect me if I'm walking up and down the sidewalk with a sign saying I love my mother, apple pie, and the American flag. I need the First Amendment when I'm going to say something controversial or unpopular. That's so. I mean, that general principle is in play here too, and you get that sense from the appellate court decision here. We're talking about a book about the President of the United States in an election year. We better be pretty careful about issuing an injunction, as you say, when a money remedy is available as well. So, but to your last point, Simon and Schuster, yeah, the appellate judge said, look, Simon and Schuster didn't sign this agreement. They're not a party to the agreement, and the judge, and this is probably a little bit too in the weeds for us to get dive too deep into this, but the judge says, look, the contract does bind Mary Trump and her agents. But then the judge goes out of the way to say a publisher is not an agent. Okay, so I mean, you literally have an agent when you're publishing a book, and the publisher isn't it. So Simon and Schuster has this material, right? They have the book; it's completed, and as far as I know, and they have their own First Amendment right to get into the field of public debate, and so that's probably going to be the real problem here for Donald Trump's brother is actually the plaintiff in this case. It's Trump versus Trump. So Donald Trump is getting his brother to do his dirty work for him to try to stop his niece, but That's what's really going to sink this case, is that if courts conclude that Simon & Schuster isn't bound. Now, you and I talked a little bit before that we started here. The Bolton case is relevant because what happened in the Bolton case was the copies of that book, and I think it was thousands of copies of that book, had already gotten out. This was John Bolton's book that the Trump administration started to stop, tried to stop that as well. And the court said the cat's out of the bag, the horse is out of the barn. It's a moot point at this point. It's not redressable, as you and I would say, right? It's not a redressable injury. There's nothing a court can do about it. I could issue an injunction, and it's not going to have any effect at all because this stuff is everywhere. The reporters have it. It's going to be published online. So if you're Simon & Schuster, right now you're not under an injunction. If I'm Simon & Schuster, I do this fast.
That's right.
What do you think? What do you think they're doing right now?
Yeah, I read the Court of Appeals opinion in this case as basically laying out a roadmap for how this thing is going to proceed from here on. The appeals court essentially said we don't have enough to hold Simon & Schuster to any kind of injunctive restraint at this point. That's essentially greenlighting Simon & Schuster to immediately start sending out PDF copies of this book to everybody on the planet who might possibly be interested in reading it. Let that cat out of the bag. The appellate court also said, though, hey, look, even if we're not talking about injunctive relief, the plaintiff still has the potential remedy of damages available. And indeed, the plaintiff in this case knows that because as part of his lawsuit, Trump's brother asked that the court find that Mary Trump has broken the contract and that damages should be awarded. Well, that's kind of the plaintiff saying, hey, we've got a remedy at law here. We just would rather not have to stand on that remedy if we can prevent the book from being published. The Court of Appeals has essentially said, sorry, you can't prevent the book from being published. So, look to damages if you want to be made whole. Now, here's where things, I think, and again, we talked about this before we went on, but here's where I think things really get interesting. If I'm the niece, Mary Trump, and Simon & Schuster, I'm more than happy to say, yeah, we're going to go ahead and let this book go. We're going to publish this thing. If you want to come after us for damages, let the discovery begin. And the first request for production that Mary Trump sends to her uncle Donald is produce all of your federal and state tax returns for the last 20 years, along with all of your personal and business financial statements. And then we call up Donald Trump's lawyer and we say, we'd like to schedule your client's deposition. When do you think we might be able to do that? Within the next, 60, 90 days, right? So she and her lawyers are delighted to commence discovery against Donald Trump. Can't wait to do it. You want to come after us for damages? Let's rock and roll.
Right. If it's good enough for Bill Clinton, it should be good enough for Donald Trump, right?
Absolutely so. That's absolutely right. Yep.
Okay, so I think we've covered our bases there, but the three big takeaways, again, for anybody who's following this and wants to know what's going on. Number one, there's a First Amendment prior restraint in play, but it looks like Mary Trump at least has contracted that claim away. But that doesn't resolve the issue of the remedy. Because there are money damages available for the plaintiff here, it seems to us, I think, unlikely that a court would issue an injunction given the availability of money damages and also the importance of what's contained in the book. That's point number two. Point number three, Simon & Schuster is a different story. Simon & Schuster looks like they're going to be able to go ahead and publish the book no matter what the court says about Mary Trump. Is that fair enough?
Yep, I agree.
And remember, please, if you like this video, click like, subscribe, and share, and you can click on the little bell there so you get notifications when we post more videos. Until then, stay well and stay tuned.
Thanks, everybody.